Hi, my name is Andre Perrotta. I'm an attorney here with the Cannabis Legal Group located in beautiful downtown Royal Oak, Michigan. And today's discussion, today's topic will focus on notification and reporting requirements for cannabis licensees, specifically the notification and reporting requirements to the Michigan Marijuana Regulatory Agency, the MRA. And we'll discuss the critical nature of some of these regulations that have been passed by the MRA and how it's critically important for licensees like yourselves to strictly adhere to the new laws and regulations regarding these notification and reporting requirements. We'll talk about different levels of reporting. Some reporting is required to be given prior to the proposed change that the licensee is wanting to make. It's kind of like a prior approval or prior authorization method in which the MRA needs to see the proposed changes and then approve them prior to making the changes. And then, of course, there are other instances in which changes are made that do not require prior approval, but that nonetheless need to be disclosed within a time frame as articulated in the new regulations. And then we'll also talk about other reporting requirements that do not need to be pre-approved, but that need to be otherwise disclosed to the MRA in a specific amount of time, as I just mentioned as well, regarding different types of occurrences that may happen depending on the facility and license type that you may own. So one of the major areas of focus of the MRA in issuing their new administrative rules, specifically with regard to prior approval and notifications to the MRA, was with regard to what they classify as material changes. They don't really define a material change as much as give examples of what constitutes a material change. But in a general sense, a material change in its most basic form and its most common form as it applies to a cannabis licensee is usually in the sense of a change of ownership, a change in a member, if it's an LLC or a shareholder, if it's a corporation structure, or even a manager. Those are what are classified as material changes by the MRA. Those material changes require prior approval, as I've mentioned earlier, by the MRA. So the licensee, generally in consultation with the attorney, would formally notify the MRA in writing of that type of material change. For example, a change of owner. You want to bring in a new shareholder or a new investor in an LLC. Prior to doing that, you need to notify in detail the MRA of the specific type of change you're making. And the MRA will walk you through the process too, requesting additional information regarding that disclosure, but the licensee cannot just up and make the change without receiving that prior approval. So that's the most common type of material change that requires the prior approval of the MRA. It's almost inevitable that every licensee will go through a material change of ownership at some point along the life of their business operations. Other material changes that do not involve changes of ownership, but that nonetheless qualify as material changes and thus require prior approval are changes in equipment or machinery. So this will obviously be heavily dependent on the type of license you have, like a processor license. Obviously, those types of facilities will have different types of machinery. So if you make a change to that machinery or really business operations, those changes are required to be disclosed and to be approved by the MRA prior to making that change. Other changes include attempting to change your entity name. That requires pre-approval as well as any attempted transfer or sale of the business that owns or holds the license. So the material changes are the heavy hitters, so to speak, in the regulation. They require prior approval by the MRA, and failing to obtain prior approval and just making the change unilaterally without it can result in some serious fines and other penalties, and potentially even jeopardize your license. So we want to avoid those instances where you just the licensee takes it upon themselves to make the change. So always consult with your attorney, ideally the Cannabis Legal Group, regarding any proposed change that you're making, because potentially that proposed change could be classified as a material change, thus requiring prior approval by the MRA. The MRA is taking this very seriously. In our experience, we've counseled clients to be over-inclusive in their disclosures, because it never hurts to just disclose things, even if it doesn't technically need to be disclosed. In the interest of transparency and showing the MRA that you're not only willing but doing what's necessary to abide by these new regulations as they've issued, works in your favor. We found that it works in the licensee's favor to kind of take an over-inclusive approach to reporting and notification. So those are the material change. Again, those material changes require prior approval, and they are the major changes that the MRA needs to see before and approve, obviously, before making those changes. There are, of course, other types of changes that are not classified as material changes, so they don't require prior approval, but the licensee, when making the change, nonetheless is required to report and notify the MRA in writing of such changes. Examples of that include termination of employees, for example, provided that employee is not also a shareholder or a member if it's an LLC, shareholder, of course, if it's a corporation. So if it's just a general employee, a grower, a person who has no ownership interest in the entity, you're still required to notify the MRA within 7 days of that change, even though that's not a material change requiring prior authorization. The MRA still needs to be notified. That notification usually occurs through Metric, which is the state online tracking system, as you all know as licensees. But it's still required to be timely given. The notice is required to be timely given to the MRA if the licensee wants to avoid potentially severe penalties, fines, and potentially jeopardizing the license. So the main type of non-material change that we've witnessed is the example I've given. It was the change of employment status of a standard employee. But of course, there are other types of changes that qualify as triggering a reporting requirement, but are not classified as material changes. So it's always good to consult with your legal counsel to determine what does not qualify as a material change, but may nonetheless be required to be disclosed to the MRA pursuant to the new regulations. So as I mentioned, for the material change, it's always good to be kind of over-inclusive. When in doubt, we just over-disclose to the MRA. Obviously not disclosing any proprietary information. These are just information that the MRA needs to have regarding who is running and the company and how the business is operating, essentially. We'll kind of shift now. We've talked about the material changes that require prior authorization. We've talked about other non-material changes that are still required to be disclosed to the MRA. And there are other instances or occurrences, if you will, that still also require the licensee to notify in writing the MRA. Some of these, and of course there are time frames in which to notify in these instances, which we'll talk about. Some of them, and these are more in lines of, or less along the lines of ownership and how the business is run, and more along the lines of the product of what is being sold, or the reason why customers are visiting the licensee. For example, if there's an adverse reaction to a product, the MRA needs to be notified within 1 day of knowing or having reason to know of such adverse reaction. And so obviously this will be different for different types of licensee. A provisioning center and grower, those types of licenses will have to notify the MRA if they know that their product is contributing or has caused an adverse reaction in any consumer. There are other types of required reporting to the MRA that is really after the fact. For example, any charges or, of course, convictions of the license holder or even anybody involved in the license business and the entity structure. So a shareholder or a member, if it's an LLC, any adverse criminal charge, criminal conviction, or even plea deal or civil judgment even is required to be reported timely to the MRA. And that timely here in this instance is within 1 day of a charge or an arrest or that type of occurrence happening. Or of course, as we mentioned earlier, an adverse reaction to a cannabis product that's being sold by your company. And the final, just in the context of today's presentation regarding reporting requirements, the final one we'll discuss is the required reporting to the MRA for any diversion or theft of marijuana product occurring on the premises of the facility in which you operate. And also, in addition to theft or diversion of the product, any type of criminal activity that the licensee knows or should have known that has occurred on the premises is required to be reported both to the MRA but also to local law enforcement pursuant to the MRA regulations within 24 hours of such occurrence. So obviously if you do your final inventory count towards the day and you notice a discrepancy, if that discrepancy cannot be readily reconciled, that would constitute a diversion of some type of marijuana product, thus triggering a reporting requirement within 24 hours to the MRA and to the local authorities. Similarly, if you notice some criminal activity, and this can be something as mundane as criminal trespassing, your security cameras pick up some unusual activity on the premises, that type of activity needs to be reported as well. Any type of, God forbid, armed robbery or burglary at the place, at the facility where people are attempting to divert or steal product or steal cash or other resources, those would obviously need to be reported as well. But any type of criminal activity, and the regulations don't really specify whether it's misdemeanor, of course, or felony. So any type, even misdemeanor type, low end level type of criminal activity, whether they're occurring by employees or members of the organization or outside third parties, as long as they're occurring on your facility's premises, that would still need to be reported to the MRA. And then, of course, like I mentioned earlier, any type of loss or diversion of product would have to be reported as well, because as you know, as licensees, all of that is continually tracked in real time in metric. So the overall purpose of this presentation is really to highlight the seriousness in which the MRA takes all of their newly minted regulations, but in particular these regulations as they regard notifying and reporting to the MRA. We've had instances where we've helped clients, really saved clients, where they've failed to notify the MRA in the timely fashion, and they've come to us and said, please rectify the situation, and we worked with the MRA in doing so, in rectifying it. But it's much easier to do it the right way, the compliant way, and do it in a timely manner within the timelines as required by the regulations, as opposed to burying your head in the sand or thinking, well, we'll just do this now and ask for permission later. The MRA doesn't look kindly on that. And frankly, they don't look kindly even on instances where you're not attempting to circumvent the regulations, you're just even forgetful. They want you to be on top of things. So as licensees, you have realized the arduous process that involved actually obtaining your license. And so you want to do everything in your power to minimize the risk of jeopardizing that license that took a long time and a lot of effort and a lot of money to procure. And failing to notify the MRA pursuant to their new reporting regulations is one way to seriously jeopardize that license, of which you put a lot of time and money and effort in obtaining. And so it's critically important to comply with all the regulations, but in our dealings with clients and with the MRA, we've noticed that they've taken a strong stance with regard to their notification and reporting requirements. So the attorneys here at the Cannabis Legal Group are readily available and happy to assist any client and any cannabis company that's not a client in complying with these notification and reporting requirements, because again, they are taken very seriously by the MRA, and failing to adhere to them could result in some severe penalties and fines and other infractions against the license. Thanks again for joining me today. Again, my name is Andre Perrotta. I'm an attorney here at the Cannabis Legal Group, located in beautiful downtown Royal Oak, Michigan. This video can be accessed via our website and also our YouTube and Facebook page, so we hope you check it out, and you join us next time for another one of these sessions. Thanks.